Philippine Legal Doctrines, Part 1. Doctrine of Absolute Privilege. The doctrine of absolute privilege protects persons from claims alleging defamation, where the alleged defamatory statements were made by members of legislative assemblies while on the floor of the assembly, or communications made in the context of judicial proceedings as part of a trial. Doctrine of Absorption of Common Crimes, also called Hernandez Doctrine. It states that the ingredients of a crime form part and parcel thereof, and hence are absorbed by the same and cannot be punished either separately therefrom or by the application of Article 48 of the Revised Penal Code. It held that the crime of rebellion under the Revised Penal Code of the Philippines is charged as a single offense and that it cannot be made into a complex crime. Doctrine of Adherence of Jurisdiction. The doctrine of adherence of jurisdiction is the principle that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do in the exercise of that jurisdiction. It is a doctrine that holds that even the finality of the judgment does not totally deprive the court of jurisdiction over the case. What the court loses is the power to amend, modify, or alter the judgment. Even after the judgment has become final, the court retains jurisdiction to enforce and execute it. It is also called the doctrine of continuity of jurisdiction. Doctrine of Adherence to Judicial Precedents, also called the doctrine of stare decisis. It requires courts in a country to follow the rules established in a decision of its Supreme Court. That decision becomes a judicial precedent to be followed in subsequent cases by all courts in the land. Doctrine of Alter Ego. It is a doctrine that is based upon the misuse of a corporation by an individual for wrongful and inequitable purposes, and in such case, the court merely disregards the corporate entity and holds the individual responsible for acts knowingly and intentionally done in the name of the corporation. The doctrine of alter ego imposes upon the individual who uses a corporation merely as an instrumentality to conduct its own business liability as a consequence of fraud or injustice perpetuated not on the corporation but on third persons dealing with the corporation. Doctrine of Apparent Authority. It is a doctrine under which acts and contracts of the agent, as are within the apparent scope of the authority conferred on him, although no actual authority to do such acts or to make such contracts has been conferred, bind the principal. The principal's liability, however, is limited only to third persons who have been led reasonably to believe by the conduct of the principal that such actual authority exists, although none was given. In other words, apparent authority is determined only by the acts of the principal and not by the acts of the agent. As discussed in Banate v. Philippine Courtside Rural Bank Incorporated, GR 163825, July 13, 2010. Doctrine of Assumption of Risk. It is the precept that denotes that a person who knows and comprehends the peril and voluntarily exposes himself or herself to do it, although not negligent in doing so, is regarded as engaging in an assumption of the risk and is precluded from recovery for an injury ensuing therefrom. It is also called Doctrine of Voluntas non fit injuria. Doctrine of Attractive Nuisance. A legal doctrine that makes a person negligent for leaving a piece of equipment or other condition on property which would be both attractive and dangerous to curious children. These have included tractors, unguarded swimming pools, open pits, and abandoned refrigerators. Liability could be placed on the people owning or controlling the premises, even when the child was a trespasser who sneaked on the property. Doctrine of bar by prior judgment in remedial law. It is a concept of res judicata, holding that when, as between the first case where the judgment was rendered and the second case that is sought to be barred, there is identity of parties, subject matter, and causes of action. In this instance, the judgment in the first case constitutes an absolute bar to the second action. Doctrine of caveat emptor, also called the doctrine of let the buyer beware. A warning that notifies a buyer that goods that he or she is buying are as is or subject to all defects. The principle under which the buyer could not recover damages from the seller for defects on the property that rendered the property unfit for ordinary purposes. The only exception was if the seller actively concealed latent defects or otherwise made material misrepresentations amounting to fraud. Doctrine of command responsibility. The doctrine under which any government official or supervisor or officer of the PNP or that of any other law enforcement agency shall be held accountable for neglect of duty if he has knowledge that a crime or offense shall be committed, is being committed, or has been committed by his subordinates or by others within his area of responsibility, and, despite such knowledge, he did not take preventive or corrective action either before, during, or immediately after its commission. Doctrine of comparative injury. A rule in equity which states that although a person is entitled to injunctive relief, if the injury done to the respondent or the public would be disproportionate, then injunctive relief must be denied. Doctrine of comparative negligence. It is the doctrine that allows a recovery by a plaintiff whose own act contributed to his injury, provided that his negligence was slight as compared with that of the defendant. Doctrine of compassionate justice. It is the doctrine that the harsh provision of law and the rigid rules of procedure may sometimes be tempered and dispensed with to give room for compassion. Doctrine of completeness. It is the doctrine that holds that a dying declaration to be admissible must be complete in itself. To be complete in itself does not mean that the declarant must recite everything that constituted res geste of the subject of his statement, but that his statement of any given fact should be a full expression of all that he intended to say as conveying his meaning in respect of such fact.